Good morning. This is Senate Judiciary. We're meeting today on youthful offender as part of our review of both laws, which have created some confusion in the public realm, but also are seeking recommendations for updates to both laws to make them more effective and make them work, I guess. So our first witness is Commissioner Sean Brown, Commissioner of the Department of Children and Families, and I call your attention to his, in our document section on the website on youthful offender status. Commissioner, and I think you have Tyler Allen with you this morning. So.
Yes, good morning. Yes, with me today, I do have Tyler Allen, our Adolescent Services Director, and I also have Katerina Lazias, who's the Senior Advisor to the Commissioner as well, and she'll be assisting throughout the PowerPoint along with Tyler and myself. So Katerina, if I can jump right in, if that works for the committee. Yep. With the presentation.
Peggy, do you want to put that up on the screen? Okay.
So Tyler's just going to walk us through the first couple slides. Tyler, if you want to take the lead here.
Be happy to. Thank you, Commissioner, and thanks to the committee for having me. My name is Tyler Allen. I'm the Adolescent Services Director over at Family Services Division of DCF. So I'm aware that the majority of this committee is quite familiar with youthful offender as a law, but I think we thought in having a conversation about youthful offender status generally, it would be valuable to have a little bit of orientation as to what youthful offender is. We do recognize that there has been a bit of confusion between raise the age, youthful offender. Youthful offender can be a very nuanced project. So I'll give, and I'm also aware that there's others here that can get into a more in-depth overview of what's happened, but I figured a good starting point would be to just do a general background of the evolution of youthful offender. Katerina, if you could advance the slide, please. So initially, youthful offender status began in 2009, and the idea was to have eligibility to those youth who committed offenses that were under the age of 18 years old. This process was a hybrid status. Youth were assigned supervision to both Department of Children and Families and Department of Corrections, and one department would be the lead on these cases. So it was kind of a dual supervision role with one department leading. And for consideration, the individual had to complete a risk and needs screening. This is the YAZI that we've testified about in previous meetings. I think we've talked quite a bit about the YAZI. And after the completion of that YAZI, the court would consider three questions: public safety, amenability to treatment, and availability of services in the juvenile justice system. At this point, we're just talking about under 18, and these were under 18 years old, and these were felony or Big 12 offenses. But then there was some new legislature in 2018, which changed youthful offender at large. And if you could advance the slide, please, Katerina. So some significant changes happened at that point. At that point, we opened it up for 18 to 21-year-olds to be afforded the opportunity to be considered for youthful offender status for any offense. There would need to be, these would need to originate, originally they would be in the criminal court. Let me see. Sorry, I just realized I lost my place in my notes. Sorry. If it originated in the family court, it would be a 100% confidential process, but what we're seeing is the majority of cases were motion to transfer cases from the criminal court down into the family court in this with youthful offender status. It did allow the cases to be filed directly in family court, although, as I said, more often it goes the other direction. There was the removal of the conditional plea of guilty at that point with the criminal division as a requirement of the youthful offender status. And so there's some challenges attached to that. And we'll see in the next slides on what challenges came out of there. There is a presumption of diversion for those of lower moderate risk youth, and those would be as assessed by the YAZI screening instrument. And it led to the creation of the Youthful Offender Consideration Hearing. If we could advance one more slide, and we'll show you the court data that I think this committee has seen some of these data before, but largely what happened here, if you'll see, between fiscal year 18 and fiscal year 19, there was a huge change in the number of filings that occurred over time. And this was as a direct result of the expansion of the youthful offender law. And this kind of, I think in the future slides, Sean will be able to speak in a little bit more detail, but with these comes a great deal more process. We see that there is a new, at least one new hearing that will be required on all of these filings. There is the completion of a consideration report. And of course, there's workforce time associated with that. I think at that point, I can move it forward to the next slide.
Senator Hughes, may I ask a question of Tyler?
Yes, go ahead.
Of course.
At some point, Tyler, do you or Commissioner Brown have information on those cases of how many, or is it too soon to say how many of them were successful in their youthful offender status, meaning that they followed all the rules they were supposed to, and how many were not and were actually transferred back to criminal court?
Thank you, Senator White. That's a great question. And we don't have the real data. What I can speak, or the exact data, what I can say is the majority of cases are successful through the youthful offender process. This is a nuance between our two systems, how the Family Services Division systems are able to track these cases, kind of lumps them together in a different way than the court systems. The filings that you're seeing are court data. So this is not just, there's not that, for example, in 2019, there weren't 504 kids that we were talking about. It was 504 cases. So this is another question that's going to come up as we go forward around youthful offender, is that the same youth can be kind of admitted into this youthful offender consideration process multiple times with each new charge that's acquired along the way. So these aren't real numbers of kids, these are real numbers of filings. And I think it's more reflective of the work that goes into managing these cases, but not the exact number of kids. I will say that anecdotally, I can say the majority of young people going through the youthful offender process are successful through that process. Commissioner Brown, I think you were going to take the next slide.
Yeah. And I would say, as Tyler indicated, many of the youth successfully complete their youthful offender status and transition out after successfully completing the program. And I would say some of that's due to, DOC, the Department of Corrections, and the Department of Children and Families both participate in the management of youthful offender caseload. And I would say that we really work well together, and we've strengthened our coordination and communication and making sure we're serving these young adults in the best way possible. And I know Dale is here as well and can speak to that, but I would say, but that also, we've also been able to outreach into the community and better educate our communities and stakeholders that we work with about youthful offender, so that we're making sure we're getting kids connected to the right services, and everybody understands what what the goal and the purpose of the youthful offender program is. And so I think in general, we've done a really good job of coordinating and communicating and making sure all of our stakeholders understand what we're working towards with the youthful offender program. And so that as a result, we've really been able to increase community engagement and implement the program to the success of many youthful offenders. And just as we've said, the majority of youth have successfully completed their youthful offender probation, and as a result, no longer have a criminal conviction and are free from the negative collateral, consequences that we know can follow someone, when they commit a youthful, offense. And the whole purpose of this is to make sure people get youthful offenders get the services they need, but also that they're not haunted by a decision they made when they were younger throughout the rest of their life. And so I think in general, the program's working well for the majority of the youth in the program. There are some challenges, that we're experiencing with the program, to be fair. One is, since its inception, we've seen the volume of the cases load increase significantly. Also, the additional requirements of the program, now having 2 court hearings, the youthful consideration hearing and then a merits hearing, it does increase the workload. We have to write on that, ask our staff to write additional consideration reports, and it's also additional workload on the judiciary. And also I would point out, DOs, the Department of Corrections and DCF both assign staff to work with someone in the program while there's a primary lead, but we're all working with that youth. And so it is a staff intensive for both of our organizations for this program, just to point that out. And then also youthful offender eligibility is not limited. We can have a youth, as Tyler indicated before, those are cases in the data before. And we can see young offenders come back through for new charges. And so the question is, I think there's a policy consideration in there that needs to be evaluated should that be allowed to occur, that multiple youthful offender considerations, and also depending on the nature of the new offense as well.
Can I ask a question, and maybe I'm getting ahead of you? On that last bullet point, are these kids who have committed several crimes as part of the same incident, or are they committed a crime in September, then one in October, and you're asked to redo it for both?
Yes, it's the latter, Senator, where someone is on it and then they occur new criminal charges, and then so there's a whole new consideration process for those new offenses as well.
So it starts all over again.
Yes.
Okay, thank you.
Mhm. And then some additional challenges that we've identified. As Tyler indicated before, there's no longer requirement of a conditional plea before a youthful offender. And that's led to some challenges in terms of providing services. So we have youth who are coming in and denying activity, or we have to be very careful about our assessment and screening processes while we work with youth because they've not been adjudicated. And if there is a violation, they could be sent back up into the adult court, and then there could be an adjudication process there. And so there's, self-incrimination, considerations that we need to be aware of. And it is hindering our ability in some cases to make sure we're providing the proper services to youth as a result of that change. We are seeing that. Also, if there's a change in circumstances prior to adjudication, like as we just talked about additional cases or charges, there's no clear process or way to rescind youthful offender status prior to adjudication. So if you have someone who's accruing new charges, yet they're on youthful offender, and it might be appropriate to revoke that status. It's a very complex process, and to understand how that works. Tyler, I didn't know if you want to add into that at all.
I certainly could, Commissioner. There's a number of cases that we've seen where there is a young person that is still awaiting disposition on their youthful offender status, has had a new charge applied to them for crimes that are of significant concern to the public safety, and they've been within state, out of state, in all manner of places. In some cases, we have young people who are in another state, incarcerated, dealing with this new charge, yet they remain live on youthful offender status here for a determination. in some of those cases, there was probably significant concern to the public safety where those young people have been located.
Can I just comment or ask a question, and maybe folks who testify later can respond to that? Number one, I completely understand and have been through what you're talking about with the YL status that denies responsibility for the charge. I remember a kid that I had who stayed probably an extra 6 months at 204 Depot because his lawyer told him you can't admit to the crime while the case is still being decided in delinquency. And that really hurt our ability to deal with the kid for those 6 months. Once the court case was settled, he became probably one of the model residents we ever had. But it took that whole period. We couldn't talk about what he had allegedly done. So I completely understand that. Secondly, the question of secure placement, understand for the raise the age kids, why that would be an issue. But frankly, if they're so dangerous that they need a secure placement, how would they get by the public safety requirement within the YO law?
Well, I think some of it, Senator, ties back to what we spoke about earlier, where there's new charges that have happened and then waiting for someone to be picked up, and then that process to work through. And then I would say, I think you'd heard us in earlier testimony speak to, we probably need a better screening tool to assess dangerousness to see if we have the right information available to everyone involved in the court regarding whether there's a public safety risk involved in granting youthful offender status. And so I think we're seeing that tool could be utilized both in the Raise the Age program and also youthful offender. And that's something we're continuing to evaluate, whether there's a better assessment tool that we could be utilizing, particularly regarding the public safety component of youth consideration of the youthful offender.
If I may add, Commissioner, I think you're right, Senator Sears, but part of that is we still need to do the work, which means do a new consideration report, have another consideration here. There are still those kind of steps to completing and kind of closing the loop on the youthful offender status, even if we have a case where there's a young person who's dealing with kind of much more significant or severe charges outside of the current youthful offender status we have open.
Thank you.
And then I think that leads to the point, I think we mentioned it briefly, that the standards for revocation of youthful offender status are not clear. And we have had some instances of pending revocations where there has been a risk to public safety. And I think we just want to we believe that there should be more clear standards on the process and timing of a revocation of youthful offender status before we see a situation escalates and that there's a risk to health and safety of the public or to the youthful offender themselves.
Right. Makes sense.
And if we move to the next slide, there's some things that we're reviewing right now in terms of possible proposals to make enhancements or improvements to the youthful offender program. Certainly understand the complexities around this, and there might be multiple ways to achieve what we're looking here, but some sort of language that returns to the prior practice of requiring a conditional plea before youthful offender status is granted. Language that if a youth or emerging adult's been denied youthful offender status due to public safety concerns, amenability or treatment, or lack of services, that future cases be a presumption that they're not eligible for youthful offender status consideration. unless there's been a significant change in the circumstances. Also, I think this goes to the public safety and whether it's an emerging adult that we believe we have the services or the ability to serve. That when the court is considering the youthful consideration report, that there's an increased deference to DCF's recommendations of whether we believe there's adequate services or that we are the appropriate place for that youth to receive services. And then also language that outlines clear criteria for the timing and process of revoking youthful offender status.
Commissioner,
Yes.
if I could ask about that last piece, the second bullet point, if a youth has been denied YO status due to concerns of blank blank or lack of services, are you suggesting that that person would then forever be considered ineligible because the first time they applied, the state was delinquent in providing services?
Yeah, and I think that's why I used the Senator a presumption there, because I believe that circumstances and facts can change over time or circumstances. And so services is definitely one of those components, as you've identified, where we might be able, that service might be available now in our system of care, and we're able to. I think particularly for us, the concerns around public safety and amenability to treatment are more important areas of focus for us, where I think those are our greater area of concerns here.
But I guess it doesn't make sense to me that somebody would be in effect required to rebut a presumption that had nothing to do with them. So public safety and amenability to treatment speak to the youth under consideration, but services provided by the state speak only to the state's ability or inability. So why should that youth need to, in the future, rebut a presumption that they had nothing to do with the reason why they were initially denied?
Yeah, I think this is a very fact-specific area, Senator, where it may be because the needs of that offender are so unique that we just do not have the services, and we would not be able to develop the services. And I think particularly one area would be regarding someone who's been charged with sexual offenses, where it may be more appropriate to receive services through DOC, where they have different services available, and Dale could speak to that as well as one area. I know that there were some questions from the committee that they wanted us to answer, and that's one area I think where there's not good assessment or treatment tools available for this area of youthful offender population versus if they were in the adult system. And
I can see that as a case specific example, but as you lay it out here, it seems pretty, if we were to just codify the second bullet point, it would essentially say that if the state wasn't providing services, then nobody could get youthful offender status. Because it would be, the presumption would be on them to rebut. So I just flagged that last piece for nuancing as we draft legislative language.
May I have a follow-up, Senator Sears?
Yes, you may.
So I noticed that you talked about the difference between the services in DCF and in DOC and around this one specific issue. But DOC has services in the community. It's not just, so couldn't those services be provided to the youth on a youthful offender status? Just because they're provided by DOC shouldn't mean that they have to have a criminal be charged as a non-youthful offender. I don't quite understand why, if services are available in the community, regardless of who's providing them, they couldn't access those on youthful offender status.
Yeah, and I don't want to speak for the for DOC. They're on the testimony and could probably more speak to that to your question, Senator. So I would defer to Dale, but I know that they've certainly had their challenges in terms of working under the youthful offender status for offenders, and I would defer to Dale to answer your question.
I think it's been raised as, a concern that we should continue to look at. What is it meant by lack of services? Is it, in Bennington County, I don't have one recovery bed for recovering substance abuse. So that'd be a lack of services in Bennington. But in Burlington, they may have 20 beds. So is that what we mean by lack of services? Or do we mean that person's problems are so immense that there's just no services available in the community to deal with? I think that's what we really need to better understand. What and I know it's in current law. So, but as I recall writing that in 2018, I think we intended the latter. Not that there be geographic issues or lack of services in Bennington would disqualify somebody who might get youthful offender status in Chittenden County.
Senator, I think I would agree with your assessment. It's really about that that the needs are so immense, not that there's a geographic or a lack of services of one type in one area that we're referring to. We're quite adept in our services of making sure, we provide that service, whether they live in Bennington or Brattleboro. If they're in a need, we find that way to get them access to it, whether it's in state or out of state or whatnot, depending on the need. I think it's more of looking at the needs of that particular youthful offender.
I think we have to, as we work on this language, I think we have to zero down on how do you define lack of services.
Senator Sears, could I also ask a question?
Yep.
Commissioner, I'm going to focus on the phrase amenability to treatment. If a youth has been denied because they have refused to engage, for instance, in some kind of domestic abuse counseling, and then they are subsequently charged with a drug offense, but they are amenable to being treated for that, why would we deny them youthful offender status?
In our experience, it's more of we run into once someone's not amenable, it doesn't matter the nature of the offense. It's more of that their failure to engage in services and want to be in receiving those services. It's not in response to a particular type of service in one area or the other. That's been our experience.
I'm just worried about those who might be charged with one thing that they really don't acknowledge and then are denied youthful offender status. But in a subsequent proceeding, they are completely admitting and agreeable to whatever programming is available. I'm just a little concerned as to why we would automatically exclude them from gaining that status. I'll leave it at that for now. It's just something to think about.
Well, it's current law.
If I could just add in very quickly, I think when we were starting to originally have conversations around this, I think it was the idea that youth's behavior would be a driving factor behind this. And I think some very good points have been brought up related to service provision and amenability to treatment if we have different factors coming in, but this be a kind of driven by youth behavior and the circumstance surrounding that youth's behavior.
Okay, other questions? This is the question. I guess, I'm going to ask if I look at the questions that Senator Eric Fitzpatrick sent Commissioner. You had 4 questions. Do you want to try to cover them now?
Sure. Yeah, and this would be in terms to raise the age, I believe, is most of the
Yeah, the
questions that
mostly
focus
raise
on.
the
Yeah.
age, yeah.
Yep. In terms of the time frame, one of the considerations regarding, requesting to kind of step back and take a pause is that it has been challenging during the pandemic on our systems of care in general. And many of our existing systems of care are stretched beyond belief right now, and we're going to extraordinary lengths to stabilize and make sure they're able to continue to provide services. It's been even as challenging to stand up new programming as well. And as you recall, in the 21 Budget Adjustment Act and the 22 build, there was resources allocated for Raise the Age to develop new programming, particularly residential type of services. And so we have recently stood up one program in Central Vermont we're working with. We're close to an agreement for one in your area, Senator Sears. And so it's just taking us longer than we anticipated to, given the current dynamics of the pandemic, to get programming up and running and staffed and work through all those challenges. And then I think we want to be able to assess those services a little bit to understand, are they the right services? Are they meeting the needs? Do we need to tweak them? Do we need to change them? So there's that aspect of it as well. And then there's, also, similar to the conversation here, there's some policy considerations that we've identified that we'd like to address too. And I think it's dependent on that as well. So I don't want to put a time frame on it, but I think we're at least looking at least a year, maybe a little bit longer on the pause. But I think there's still some unknown details of what that will look like moving forward. But I hope that answers some of your questions, Senator.
Yes, it does. So 12 to 18 months.
Yeah, I would say that that's a good estimate. And then, as you indicated, we are standing up a couple. We want to see how those look. We are currently under our process for developing the Budget Adjustment Act for the current year and the budget for 23. This is an area we're looking at. So, and any needs we identify, further needs we identify, we would address through those normal the budget processes, just as we had last year with Raise the Age. And so you shouldn't be surprised to see policy or budget items regarding this as a result of that work. And then in terms of number 3, we've given some thought to number 3, and I certainly understand the idea behind, addressing the problem of youth aging out. I'm also sensitive to at what point is it no longer appropriate for the Department for Children and Families to be serving someone? Is it 24? Is it age 25? Is it 26? So to me, I worry it could start to dilute our mission of who we focus on in our area of expertise. And so I think this is an area that needs more discussion and understanding what the parameters of that might look like before moving forward. But we're certainly happy to have that conversation and see if there's a solution to be found there. But I recognize the concern that's identified in that question.
Well, it mainly comes from the idea that if somebody is 18 years for 6 months, you only have 6 months to work with them as a juvenile. And how do you know that 6 months isn't going to make that? You just don't have enough time.
Sure.
And I think it's an age-old question. It's true for the current kids that are in DCF custody, who are 17 and a half, yet used to be a big problem. Because they had 6 months.
Mm-hmm.
And the other one was about risk assessment. And we touched on that last week, and we touched on it here today. That risk assessment appears to be not applicable for sex offenders.
Correct. And in working with the Department of Corrections, we've identified that the current tools work more for older offenders than younger offenders. So there's not a specific tool for juvenile offenders. And as a result, you probably would have to do a much more comprehensive psychosexual evaluation, which are very large evaluations to complete. And that, Dale, I didn't know if you wanted to jump in here as well, given our conversations in this area.
Dale Crook from the.
Yeah. Good morning, committee. Actually, with
Morning,
me, I
Dale.
brought Gary Marvel, who is one of our operations manager. He is has a subject matter expert for the department on sex offender treatment and supervision, and he has some information regarding the assessments for youth and sex offenders that he can share.
Hello. I guess I can just jump in. Thanks, Dale. Yeah, so I went to the recent Association of Treatment of Sexual Abuse conference, which is kind of like the worldwide conference that talked about this at length. And this has been a problem in the field for a very long time. But basically, the gist of it is that in a comparison, if you were to look at adult, which is the 18 plus crowd who committed their offense after that age, and you were to assess them in the adult system, there's actually an adjudication for a criminal offense. We have a robust size. We have enough data that we can develop. We have developed reliable instruments that can speak to reoffense rates. One of the problems we have with the youthful and the transitional age population who haven't been adjudicated is that the population is pretty low and the reoffense rate's pretty low as well. The population size is not large enough to get adequate data. And a lot of it is the complexity of the cases as well. It makes it very difficult for a layman like any of us to be able to just plug in a risk instrument that looks at like 10 demographic information questions that can give you a rough idea of what reoffense is likely to look like in terms of the likelihood. Whereas with transitional age youth, you're going to have to get a clinician involved who's going to be able to look at sort of protective factors, risk factors, contextual relationship situations in the youth's life. And that's a much more complicated process. And a lot of clinicians nowadays won't even speak to what the likelihood of reoffense is because it's just too difficult to assess. And it's more about looking at the specific factors that need to be addressed in each case. I can answer more specific questions if anyone has them.
I think that completely complicates the issue. I appreciate your testimony, but I was hoping there was a simple answer.
Senator, unfortunately, there is not.
Well, all right. Other questions for Commissioner Brown or any of his team? Commissioner, thank you very much for the concise testimony. I got one final question. I got an email from folks from Newberry this morning wanting to make sure that they had a number of questions, but I'm not going to do all of them. It is our understanding, and it's your belief, that the Newberry program will not take persons over the age of 18. Is that correct? You're muted, Commissioner.
My apologies. Yeah, you are correct. We do not intend to have that program, nor did we apply for a permit to serve 18 and above. That program will serve under 18 youth.
Thank you. Clarification. Senator Benning, do you have any questions? Question for Commissioner? Senator White.
So I've been getting the same emails from the folks in Newberry and also have seen some stuff on Digger. And I wonder if sometime we can just have a conversation, not necessarily today, but a conversation about the project in Newberry and why it's taking so long and is that still really the right place? I mean, I'm getting more and more confused about that project all the time and wonder if there are other alternatives that could have been better. And so at some point, I would like to just have a conversation about that and have more understanding about what's going on there and why it's going on there.
Happy to have that conversation, Senator.
Thanks.
Senator Sears,
Benning.
if I can just clarify, the reason I don't want to ask any questions at this point on this subject is I've told both sides of that discussion that I want to remain out of it until the normal process works its way through. I agree with Jeanette that we need to have a conversation generally about this subject, but since this is literally in the middle of a process, if you will, I was very reluctant to get involved and inject myself as a state senator in this region, because I'd essentially be forced to place myself between one side or the other, and both sides are constituents.
Understood. And it's difficult.
And just for the committee's consideration and just knowledge, as Senator Benning indicated, we are in the midst of a process. And so we have gone through the process for an Act 250 permit. It is pending a decision by the Act 250 Commission for that district. And then also we filed for a local permit with the Development Review Board in the town of Newberry. There's been a series of public hearings on that permit. The record closed after a hearing on last Thursday evening, and now we will await a decision from the local Development Review Board on the permit as well. And so we're pending decisions on both permits.
I appreciate that and appreciate the answer. I'll just comment that from my perspective, what's long been needed is some kind of secure placement for young people aged 16 to 22 that is separate from the traditional DOC lockup. And all we've learned from the Justice Lab at Columbia University, all we've learned about adolescent brain development tells me that putting kids who are 19, 20, 21 into correctional facilities with older adults is not a practice that gives you results that will, in the long term, protect public safety and provide for rehabilitation. It's the highest recidivism rate of any age group. It's the highest rate of racial disparities of any age group. And so I think while we, and I use the term 16 to 22, obviously 16 and 17 are very different from 18-year-olds. That conversation needs to be ongoing about what we do in terms of secure placement for that age. Thank you. Our next witness is Dale Crook, who we've already heard a little bit from. And I thank Commissioner, thank you and your team for the very well done presentation.
Thank you, Senator.
Good morning, committee. For the record, my name is Dale Crook, Director of Field Services for the Vermont Department of Corrections. And with me, I have Gary Marvel, who is one of my operations managers. I'm not really sure what additional testimony. I do know that Commissioner Brown's presentation on youthful offender kind of, I think, set the stage very well for the issues and concerns. The department is in agreement with some of the recommendations that was in Commissioner Brown's presentation today. When it really comes to raise the age, there's really a minimal impact on the Department of Corrections, while there is a large impact on the DCF. Really for the department, it is a few cases, either additional cases or less cases coming into our system. And we're able to deal with the ups or downs of that process. So I think at this point, I will open up to any additional questions around youthful offender or any questions the committee may have.
Maybe you could just give us a sense of the process of dual jurisdiction over a youthful offender case.
Well-
How, if the kid who is designated as a youthful offender is doing well, what's DOC's role? If they screw up, what's DOC's role?
Yep, I will do my best. I mean, of course, every case is different.
Oh, yeah.
Just in general, though, the management of a youthful offender case is complicated and kind of clunky. We have two systems trying to work together, and the systems, while the outcomes of public safety and rehabilitation are the same, the kind of the process and the philosophical underpinnings of those departments are a little different. So there's a few complicating factors for the DOC when we're dealing with youthful offender statuses. One's the confidentiality. So the department had to create an entirely separate database system from our original offender management system, just to be able to manage the data collection for the youthful offender population and to create the notes and things of that nature. A lot of times, really, there's a process where if, in general terms, and Gary and Commissioner, please chime in general terms, the case started before the age of 18 and the case is going well in completing case plan requirements, generally the DOC never becomes the lead. And the way I like to describe the lead is kind of like a pilot and a co-pilot. The pilot's kind of driving the case and the co-pilot's there to assist. Cases that begin kind of after the age of 18 are having complicated factors in their compliance will be shifted over at times, generally over to DOC as the lead. And really what happens when someone's on youthful offender status after the age of 18, they're kind of in a situation where nothing really fits well for them. There are services, we can get providers for them. But they're kind of in this limbo where they have this protection of family court confidentiality, and we're trying to work with them in the adult system. So, the Department of Correction works in an adult system, and we try to apply our science and our supervision strategies to an individual that has all the confidentiality requirements. So it is complicated. I think, the outcomes are generally pretty good on some levels. Talking what Tyler mentioned is that mostly are successful. So this is our most intense supervision requirements for the department. So this is the only caseload requirement that is, if they're a youthful offender or youth only caseload, is 25-1. So it's the department's most intense caseload, and I assume it's a pretty high resource intense for the Department of Children and Family as well. So a lot of resources that go to each individual case, so sometimes I think it depends on are those resources necessarily needed for each individual case, and that comes down to risk and needs of the youth. I'm not sure if I'm answering your questions, or if Gary, if you have any additional information.
Actually, you are, and
Okay.
I can understand the complexity of it. So it's helpful, Dale, to
No, and
hear your
just,
co-pilot.
and just for an example, like how there's two different systems trying to work together, and we have, I think Commissioner Brown mentioned this, we have a great working relationship with DCF. I mean, we're trying to figure out strategies and how to manage the system and manage the population. It's just a challenging population, and I'll give an example of the differences between the two systems. We'll take polygraphs for sex offender population, right? The department views that as a treatment tool that's needed for public safety. DCF has concerns about polygraphs for this population because it could be, they don't believe it is trauma informed, because of the direction that DCF is going in a rehabilitative setting is a little bit different than how the department supervises sex offenders and a public safety mindset. So that's like an example of how the two systems are trying to get the same outcome, but their philosophical difference sometimes bounces up against each other.
Senator Sears?
Sometimes just one comment. I fear sometimes we get overly, nothing is more, I don't think nothing hits the public like sex offenders. And our concern for their behavior, whether they be, but particularly child sex offenders. So I think, if we separated out that group from the guy that breaks into your house, takes your keys, steals your car with no intent of bringing it back, and how do we deal with that 18-year-old or 19-year-old? It's a little bit, sex offenders are difficult in terms of treatment and options. Senator, so we could focus on other groups as well.
Oh, absolutely.
Senator White. Yeah.
Thank you, Senator Sears. Dale, can you have a sense right now of how many cases that you are the pilot on as opposed to the co-pilot? I mean, not how many charges, because when we saw the chart earlier, it was, I remember there was 388, I think, or something this year, but that wasn't individuals, that was different charges or cases, whatever they're called. But can you give me a sense of how many right now you are in charge of?
I don't have that number right with us. We'll have to look it up. I can tell you for certain how many youthful offenders we have, and I believe we can determine who is the lead and not lead. But we'll have to look into our database for that.
If you could get us that for our next meeting, I believe it's November 8th. Peggy will correct us.
Okay.
Thank you.
Yep.
Thank you. Other questions for Dale or Gary?
One more follow-up to that. Given Senator Sears' comment about kind of separating out the sex offenders, because that is something that just goes right to the top of the list for the public. Can you separate those out in terms of how many of those and how many other that you are the lead on?
Yes, I will. I'll try to have it broken down by charge or category like that.
Thanks.
Don't forget that many of those that receive YO status are diverted. That's another factor that we would need probably from the Attorney General's office. Other questions for Dale or Gary? Thank you both very much for being here.
Thank you.
Commissioner Sherling, welcome aboard. I use that because I know you may be aboard.
Good morning, Senator. Nice to be back on a Monday morning. I am available to answer questions. I think I successfully got all my points in a brief testimony a week or so ago. So if there's anything I can illuminate for the committee, I'm happy to do that.
What is the department's policy, and what training do we do police state troopers who are involved in the arrest of a 19-year-old in terms of the victim? I'm thinking particularly of where there was great confusion on the part of a couple who had been told by the state trooper that the person, and it was an automobile accident where he had trying to outrun the police and had caused a horrific accident. Luckily, neither were really hurt badly, but it struck me that they were of the impression that he was going to be treated as a juvenile, and they couldn't even tell him the name, yet he had gone to jail. So obviously he wasn't being treated as a juvenile, or he couldn't have been incarcerated. So I'm just curious about the training that we're going through. And I realize the the raise the age and the youthful offender are both beget confusion. And that's one of the reasons we're holding these meetings. So maybe you can speak a little bit about what's happening in that realm.
In terms of training, I will have to do some research to find out whether there is training specifically or whether this is just based on the existing policy overlay. Right now, the policy on publicity for youth that may end up in the jurisdiction of the family court is to hold that information pending a decision by the prosecutor, or it may be, the system may govern which system the offender ends up in, or the alleged offender ends up in. But basically, we're supposed to hold that information confidential until or unless that offender's case goes to criminal court. If it goes to the family court, then the law, Title 33, clearly states there can be no publicity, and we can't disclose the name of the accused in that circumstance.
But if it's going through a youthful offender process, maybe that was part of what Dale Kirk was pointing out, the differences. If it's going through the youthful offender process, you wait until there's been a determination. Is that what I'm hearing?
In a perfect world, yes, but there are all kinds of nuances to the way these cases flow. So, for example, there is case law that says as soon as an adult citation is issued, that citation is public. We're actually dealing with one of those cases right now. Interestingly, if the case makes it to the prosecutor's office and prior to being charged ends up in the youthful offender process and shuttled into family court, we believe under the current law, and this hasn't been fully tested in court yet, that there's a section of Title 33 that says the juvenile law supersedes the criminal law. And as a result, that citation that was for a period of time public information until that youthful offender process began now becomes not public information. So we recently released a citation, for example, that had the offender's name blacked out of it, even though an adult citation had been issued. So it's one of the reasons that we believe the comprehensive look at these various things that you're taking a look at is important to try to bring some congruity to the way that all of these things flow, because it is not by design, but by happenstance, because there have been many things that have grown up organically over the years. Things have become quite complicated and difficult to follow.
Other questions for Commissioner? Senator White.
So thanks, Commissioner. When you testified before, you used an example of kids or young adults bringing guns and drugs into the state and being essentially used by older people, and that was a real problem here in dealing with them. But the law says that you can, if it's an issue of public safety, you can transfer it to criminal court. So I'm not sure why in that case it presented an issue and didn't just go to criminal court.
I think what Commissioner Brown might tell you, and I would defer to him, is that there have been cases in the last year. Not again, as I testified, these aren't significant because of frequency. They're significant because of severity. So 6, 7, 8 cases in the last several months or a year that have been shuttled into the family court process and placed in on the DCF side of the house, not the correction side of the house, that are the cases that I'm describing, where DCF is feeling very much ill-equipped to deal with the level and dangerousness of the offenders that are making it to that system. So where the breakdown is, I can't speak to, and I would ask Commissioner Brown to cross-check me on what I just said as well.
And was it the court that sent it to who sent it to DCF as opposed to criminal court?
I would have to defer to the commissioner because they're juvenile proceedings and I don't have the full details
Oh,
of them.
okay. Yeah.
Before, and I could be stand corrected by either Eric or any of the other attorneys. Before 2018, if you were going to be a YO, a youthful offender status, you started in adult court, and then there was a process to move down. And I think that's where some of the confusion lies in terms of what's public and what's not public. But maybe Tyler Allen, I don't see Commissioner Brown still with us, but maybe.
Yep,
Tyler,
he is.
I am here. I'm here,
He's here.
Senator. Yes.
Can you help us with that?
Could you repeat your question, Senator?
Senator White. could you
Well,
repeat the question?
Yeah, when Commissioner Sherling testified before, he used the example of a young person bringing in drugs and guns and how that, and as he said, it isn't the frequency, but the severity. So it's a pretty severe case. But I thought that the law, as we saw it, that Eric presented it to us, said that it can, a case that has implications for public safety or is pretty severe can be transferred to criminal court. And so I'm just curious as to why, and I know you probably can't comment on that particular case, but why it wouldn't, a case like that wouldn't be transferred to criminal court if there was indeed public safety risks involved.
Well, ultimately, it's a judge who decides many of the questions of where a case falls or not after, the prosecutor and the defense attorney and DCF weigh in and provide their information, and then they weigh the information and make a decision. To Commissioner Sherling's point, we are seeing a concerning number of situations that DCF does not feel equipped to manage. And I can just give at a high level, not to provide, but we had an 18-year-old get charged with 3 offenses. 2 were smaller offenses and 1 was a serious offense, a Big 12, aggravated domestic assault. So they were not eligible under that for raise the age for that offense. The 2 smaller offenses allowed them to be, those offenses to be considered for delinquency and placed as a delinquent within DCF as an 18-year-old. However, they still had the more serious offense, and that youth was then sent to DCF under youthful offender status, notwithstanding the bar under the raise the age that was not offense appropriate for the DCF system. Again, many of the concerns we outlined today were highlighted in that one case, and subsequent offenses happened that were quite serious. That we feel it's appropriate to address them, and kind of what we highlighted as some of the issues were highlighted there. So, we had a youth on multiple statuses, delinquency on some lesser offenses, but on a very serious charge where they were ineligible for raise the age, then came in under youthful offender, where they did not even need to admit to the underlying charge to get that offense. And as a result, we're not very amenable to treatment or services, which we highlighted and unfortunately, some new more serious offenses occurred in that situation, which raised some significant health and safety and public safety issues.
So once they were given the youthful offender status, then they're no longer, I thought that under youthful offender status, if they weren't complying, it would then be sent back to criminal court.
Well, and we initiated those proceedings, but over a series of months, there was no revocation proceeding, and because it's very unclear in statute of how and the timing of those processes.
Oh,
That goes
Okay.
back to
Yeah.
several of your recommendations, one of which is to have a clear process for revocation, but also the need to have a clear determination that the person is guilty, but actually admits to the offense before they get YO status, which would go back to the way it was before we changed it in 2018. But I've also heard anecdotally, and maybe Commissioner Sherling knows about this as well as you, Commissioner Brown. I've heard anecdotally that defense bar feels it is absolutely necessary to file YO cases in every under 22 case, no matter whatever the conditions, because they feel that they would not be doing the correct by their client. And that would result in a large number of cases. And whether or not they end up in YO status or not, there's a huge number coming in. And then you have that period of time between the decision by the court where it's it's up in the air. Is that correct? Both commissioners, either one of you?
Yeah, I mean, I have heard that, but to be fair, we have seen in some areas of the state where the state's attorney file for YO in every case, and then depending on how the facts play out, may support the petition or oppose the petition later in the process, which creates challenges as well.
And I don't know the answer to that question, Senator.
Anything else for Tyler? Did you want to comment?
If I could just may provide some clarity to some of the cases that we were talking about before regarding emerging adults and some of the concerns with egregious crimes. I do think of the cases I'm familiar with, several of those cases are, to my understanding, none of those cases were youthful offender status cases. They would have been under the raise the age kind of conversation, or not even actually, they would have been traditional juvenile cases.
So what further exasperates the situation, would you agree, is the lack of secure placement on the raise the age?
In these cases, they would have been under the age of 18, so there would have been secure placement opportunities.
Okay. Well, thank you all very much. Appreciate it. Any more questions for any? Jay Johnson, if you're there, happy to hear from you.
Yes.
Morning.
Good morning. Thank you again
Thank
for. I have to say I find these probably just as educational as you do. So I really appreciate the opportunity to hear this testimony, and I appreciate the opportunity to say a few words. So first, we're still working internally to develop policy and legislative proposals. And our goal following these hearings is to come up with a package of practical proposals we can discuss with the legislature. We haven't had a chance to vet all of these with the governor yet, but we're working on those, and really appreciate the conversation and the input that you're getting through these hearings. Second, I think generally my observation is while delinquency proceedings and youthful offender proceedings differ procedurally, and I think that those differences are worth a look for really determining whether there's a policy rationale for that, I think many of the downstream impacts are the same. The total caseload falls to DCF and diversion. I think the questions regarding numbers of cases where is appropriate are appropriate. The release of dangerous young adults into the community who sometimes are then repeat offenders and recycled back through the YO process. They pose the same risks to victims and communities. The processes, we are concerned that the processes don't sufficiently address the needs and the rights of victims. And I think that their input is going to be important as well. The governor's chief concern remains the public health and safety of our communities, although we agree a major part of that is making sure that young adults have the services that they need to become, stable members of society. I think that while the program is working well, and you've heard a great deal of testimony to that effect, we can't afford to ignore the population with the risks and needs beyond the services offered through diversion and DCF. And I think, in 2019, the AG's office did a diversion recidivism study, and I think reached the same conclusion that when we do diversion well, we do spectacularly well, and that's generally with first-time offenders. With repeat offenders, we do just as spectacularly badly. We don't do well, and it's worth asking the question about that population and the risks and needs, and whether those can be served through diversion and or DCF. I think that improvements to the program need to address the population that poses the greatest risk, and need not diminish the effectiveness of the programs in place, which are appropriately serving young adults. I think those programs remain in place. Those processes would not necessarily diminish the outcomes in the success of the programs as they exist. And in this sense, the conversation is no different than the conversations we're having about DOC supervision and the gaps between mental health and our justice system. We need to match people with the services that are appropriate. Sometimes we do it well, sometimes we don't have the facilities and resources. And I think we constantly bump up against those issues, and I think we share those concerns. And I think a while ago in this conversation, Senator Sears asked a really important question about how the law is structured. If the courts now have to consider public safety, amenability to treatment, and availability of services, where are things going wrong as those relate to the most dangerous young adults in the system? The Commissioner of DCF made some specific suggestions. And I think as well as, for addressing those disparities and how the standards are applied, as well as issues of revocation of YO status. And I think, as the Commissioner just mentioned, some of the issues come down to what we often see, which is the disparate 14-county system of government, and where certain prosecutors are and where certain judges are and how they interpret the laws. Anyway, I think that's it for me. I'm thinking it's really important that we're having this conversation again. I think that it seems to me, when I talk to the folks at DCF and when I hear them testify, they're doing the best that they can with a difficult population and succeeding to a great extent, but really struggling with how to manage this really more complex, more dangerous population.
Thank you. I think that's, we said last week, and I think it's apt, is that for 95% of the kids, the system is working pretty well. It's that 5% that pose a huge challenge. And I realize in Senator Benning is chair of institutions, I wonder if there's any thought to having a correctional wing or whatever size for that small number of 19 to 22-year-olds, which could handle in a more secure setting some of those young people that might be able to provide more age-specific programming, etc., but still provide the security that the communities expect. I don't know, it's just it's off the top of my head, but I'm thinking of a wing in Rutland that's probably not being used, and they're over 18, so the issue doesn't become one of the prison rape elimination process, but keeping them separate from the general population.
I'm sure that there would be an interest in having the conversation, Dick. I'm not exactly sure as I sit here what the reaction would be.
just a thought. We have this admittedly small number. It may be fewer than 10, but they pose a, from what we've heard in testimony, it poses a great risk. And they may not necessarily be YOs. They could be people under 22 who have been, who never, were not eligible.
Jay, you may want to just shoot me an email and talk about some suggestion that the administration might want to put forward, and we'll follow up with it.
Okay, thanks, Senator Benning. We'll do that.
Yeah. Are there other?
Yeah, thank you, Senator Sears, for the suggestion.
Are there other questions or comments? Back when we started YO in, I think, 2009 or 2008, I can't remember. One of the considerations, we looked at Colorado, which had their own youthful offender facilities. And we recognized we could never build our own youthful offender facility just for enough people that needed that secure placement. So we went in the direction we went. And then when in 2018 we changed the law, we obviously opened up the YO system to a tremendously new number of individuals. And I think now we're looking at that, what that increase looks like and how it can be best accomplished. Other questions for Jay Johnson? Anyone else? Senator Ruth, you're back.
Yes, and I am boosted.
Well, congratulations. We need a new definition of fully vaccinated, I guess. I am as well. Realize when I took my wife up Saturday morning to get hers, that we had these long lines at the hospital because even though we made an appointment, other people didn't need to. And I'm really happy that so many people are taking advantage of the opportunity.
Yeah, no line at CVS in Burlington. So
Good.
Was yours
Commissioner
Moderna?
Brown.
no, Pfizer.
Oh, because Moderna we just got word the other day that we could start.
Yeah,
I got my wife got a half a dose on Saturday. Anyway, I digressed from our youthful offender thing. However, Commissioner, I know there have been problems, at least in some facilities, with COVID. I would be remiss if I didn't mention that has contributed to the challenges you're facing.
Yeah, so we've been very creative trying to support our programs to make sure that they can continue to meet the needs of the youth they're serving. We've had some of our own staff helping out in some of the programs just to make sure that they can continue to operate. And we are currently working to bring in some qualified traveling healthcare resources to help support some of our residential programs as well. And so that work is going on right now, and that should be happening very soon. It's very, they're very important to our system, and we want to make sure that they're able to continue to meet the needs of the youth that are placed there.
Well, thank everyone for being here this morning. Are there any comments, questions from any of the committee or any of the witnesses that want to provide further clarification? All right, well, why don't we take a break till get back at around, it's not even 12. Can we get back at 12:30, Peggy?
Let me see who, yep, I mean, I can send an email out to all the witnesses and ask them to come at 12:30.
Yeah, well, even if they just start at 12:30, it'd be helpful.
Yep.
And then we can, because Senator Benning has to leave at 2, I believe.
So what's the plan here now? We're on a break until 12:30?
Yeah, lunch break till 12:30. And
Okay.
then we hear from Department of State's attorneys, Marshall Paul, Judge Grierson, and a few other witnesses.